in Indonesia we have two laws. The first competition law and the second is the consumer protection law. If you talk like that, it's under the consumer protection law because the competition law and the competition law is talking about the fighting for the big company, big corporate, between corporate. They don't think about the consumer. The corporate fighting is under the consumer victim. Okay, so I don't know about in the Germany under competition. They can apply the social function about the protection. It's difficult to talk in Indonesia because we have different principle. So, and the second reaction, this is the moral, because meta ethics is moral. That we should apply Pancasila is the first moral foundation. So all the regulation should be applied to Pancasila. But if you say which moral, which ethic, we should apply Pancasila. Okay, thank you.
Let me start with the business law aspect. Later I will say something about this Pancasila aspect. The second one, first of all, we have also the concept between market regulation law, market structure law, and market behavioral law. The market structure, market regulation law is regulated in our law against constraints of the competition. This is the counter law and the merger control. And the behavioral law is the anti-competition law. What we talk now about, why is so difficult in Indonesia? Because the Consumer Protection Act is not knowing the concept of institutional consumer protection. Moreover, the Consumer Protection Act of 1999 is mixing several concepts. We find here the concept of that the consumer can give the product back if the product is defective, for example. This is in the Consumer Protection Act, but also there is the misleading information in the Consumer Protection Act, and moreover we find information also in the tort law. So you are here maybe in a stadium of the discussion, which is in stadium in Germany was maybe in the 50s and the 60s when we started to develop this concept. Yeah. So it does not mean that that concept would not work here, and the economists, I'm sure, will have that concept already, but the legislation did not yet respond to. So if I was making an amendment of the consumer protection law, this amendment should be scientifically discussed. Yeah? The other part is saying like the Pancasila question is not exactly the business law question, but it's interesting because I made a presentation on business ethics in Trisakti University, and some people asked me, is Pancasila moral or is it ethical? If we see the concept of Pancasila, what I really think it is the basis of the Indonesian state, it should be, of course, understood. Then we have two sides. We have ethics side and we have moral side. Ethics side is the pluralistic aspect of Pancasila, but the moral side is the decision that there must be certain religions and there is nothing between, and there is also no atheism. I don't want to criticize this, I don't want to discuss this, I just say the decision of a society and of the constitution to say there is only certain religions and these religions are protected. This is a concept which is a moral concept, which is a moral metaphysical concept, because it is coming from the thinking in Indonesia that anyone should have a certain religion. This is, for example, totally different in the German law. In the German law, religious freedom means you can have no religion, you have negative religious freedom, you can have any religion, you can also have a natural religion if you come from some area, cultural area in Africa, which is not Christian, which is not Muslim, yeah, and so on. This is the decision of the private individual, and this is ethic because this is the constitution. We need this to the person. But if Indonesia decide about Pancasila like this is a sort of moral, because the majority of the people is of the understanding that anyone has a religion. But this is interesting, yeah. So there are also aspects of Pancasila which are more That is this one. We should leave all people in this area do what they want, and anyone should have the same rights. If it's enforced or not, it is the other question. Yeah. But this is the, and you are totally right, so should stick to that.
I believe people in this room are very smart customers. You and me. We're aware that some products that we use daily may cause harm to our right as a customer, or because we want incentives, right?
The product or
But what should we do exactly to protect our right from the valuable brand? Should we make a petition or file a posting on social media? Or if the company?
Indonesia has one problem. There is a lot of law, which is already very modern. The legislation is not bad. I cannot say the health regulation, for example, is bad, or the Consumer Protection Act is bad. I cannot say that this is modern law. But the problem is the concept how to enforce it. In several countries, also in Europe, if there is a law enforcement of consumer protection by authorities, or like in Indonesia, it is partly a criminal law enforcement. But ask yourself, do you think that an authority, maybe with a low budget, also, or a criminal court, is interested in protecting little consumer infringements of everyday advertisement? Maybe not effective. And we can see there is a lot of consumer infringement. I'm all the time caught in my phone by cold calling. For example, the fifth time already, some photographer from Cayman called me in my phone just because 2 years ago I made some passport there and want to bring me in his shop. I did not allow him to use my number. It was really molesting me. Do you think that some criminal court or some authority will care for this? No, exactly. There is no enforcement. So how we do it in Germany? In Germany we have private law enforcement. First of all, the concurrent can claim against concurrence, and second, consumer protection authorities claim against concurrence, not the consumer individually. But this means the incentive to sue bad behavior against consumer is very high, because the consumer protection agencies, but more the concurrent, are interested in limiting infringements of overall incentives. The second one, what can you do in Indonesia as long as you don't have this law enforcement in this way? Swarm intelligence, social media, social intelligence, you cannot do much. When we talk about online development, online trade, yesterday I tried to order something online in an Indonesian shop in Bali. They made a great web page. But as soon as I paid this morning, I got email, could you please make the order again? Our mask is not working. This is typical. It looks all very good, but it's very difficult as the consumer to get it what you want. So there must be pressure of the consumer, social pressure. I'm part of that. Very difficult. Be circumspect and don't believe everything until we have the protection. But as I say, here in the room we have a lot of
I'd like to ask you about your opinion. How is it in Europe? You said for Charlie Hebdo, which is making something so secure, so inviting conflicts, because you said that ethics is something is more important in business than moral. So how is ethics more important in the market in Europe, because we don't know how the behavior of consumers in Europe, because it's so a lot of free things and liberalism. Because I think also values is the society is built from the values from the people, and when those values are disturbed, it perhaps also can disturb the market regarding. Maybe in Indonesia the character of the people is religious and maybe so they tend to respect the values of religiosity, but in Europe it's maybe more free, because maybe if we apply like that, Charlie Hebdo it will be chaotic, because it affects not as me as Christian, but also many I mean, so something can also disrupt the market, for example. How do you think about it?
That is not a question of the market for us. Yeah, this is a moral question. You must always see. This is a law for the market regulation. The law for the market regulation has a certain purpose: to not disturb the market. We had a fight between the German Federal High Court and the German Constitutional High Court on some advertisement of United Color of Benetton. United Color of Benetton used photos which were very molesting to some people. For example, they used photos of dying soldiers. You saw a dying soldier in the blood. You saw graves. You saw children working in India very hard and really, or you saw HIV. You saw the bed of someone, and there was a stamp on it, HIV. Looked like chicken, like bacon, yeah, in the pork or in the doggy. And then someone claimed that, and the German High Court, Federal High Court, had to decide: is this unfair competition using advertisement concepts or photos and advertisement which is unmoral or could disturb the good taste of the society or part of the society? And the German Constitutional Court said no, this is not to be forbidden under the Act Against Unfair Competition, because unfair competition has not the purpose to keep the moral of certain groups or of the society, and is also not the purpose to protect the society against untasteful advertisement. Yeah? It is a market function. The other point is, of course, in Europe also we use law against certain aspects. For example, we have the criminal law. The criminal law is not allowing hate speech. We have also hate speech legislation. It is not allowed to use statements to make people hate each other or make groups hate each other. Yeah? But until we come to this, we always have to evaluate it with free speech and with free opinion of the people. And that is in our society and our constitution a very important aspect, a pluralistic aspect. Charlie Hebdo, you mentioned this. Charlie Hebdo is maybe not very clever to do that. Charlie Hebdo making trouble, yeah, so social trouble. But you cannot forbid them, the concept, yeah? You cannot forbid that Charlie Hebdo makes fun, yeah? Or makes satire, because this is constitutionally allowed. But as soon as a limit is overtaken, and as soon as in a sort of satire there is a statement, kill all Muslim, something like this, or kill all Catholic, yeah? Or what also Muslim or maybe Wahhabi group or Salafi group in Germany do to the other side. That is using, and you understand German, Anstachelung zum Rassenhass oder Anstachelung zum Rassismus, Anstachelung soziale Gruppen gegeneinander auszuspielen. Social group hating. And this is a problem for society, and this is forbidden. But not under the Act Against Unfair Competition. This is a pure and mere economic function, not a moral function.